The Speaker of the Senate, Honorable Kenny Lusaka, the Deputy Chief Justice of the Republic of Kenya, Honorable Philomena Mwilu, the judges of the Supreme Court here, the judges of other courts, members of the Judicial Service Commission, led by the Vice Chair of the Judicial Service Commission, Mr. Ken Ugetu, our Solicitor General. Ladies and gentlemen, please forgive me to say all protocols observed because I didn't get the entire protocol, lest anybody thinks that I have missed him or her out. Ladies and gentlemen, and the distinguished members of the police band, ladies and gentlemen, good morning. I'm delighted this morning to welcome you all to the presentation of the State of the Judiciary and Administration of Justice Report, SOJA, for the financial year 2019-2020. But I'm also happy to see you today, as this is my last report before I retire as Chief Justice. The report, therefore, looks at our performance during this year, but also glances at the progress and challenges throughout the 4-year period of my tenure. As this is also, as it were, my valedictory speech, please allow me to also make a few observations in addition. As you are aware, Section 52B of the Judicial Service Act obligates the Chief Justice to prepare and submit a report to the nation on the state of the judiciary and administration of justice in the country, and to further submit the same report to Parliament for debate and adoption. This obligation is in tandem with the text and the spirit of the Constitution, which places accountability and transparency at the center of all governance processes. One of the most transformative provisions of our Constitution, a provision which is unique to our Constitution and which, as leaders and institutions, we need to constantly be alive to, is one that is worth restating: that judicial power and authority, like all other state power, is explicitly recognized as emanating from the common sovereignty of the people and donated to state institutions for its performance. The powers and sovereignty donated to state institutions are thus exercised on behalf of and for the benefit of the people to whom the radical title to power and authority ultimately belongs. So the delegates, like myself, should regularly report and account to the Kenyan people. For the judiciary and the justice sector generally, the The Constitution goes further to lay down specific and core principles and objects that should provide fundamental guidance and direct the exercise of judicial power and authority. Article 159 explicitly provides that judicial authority is derived from the people and shall be exercised in a manner that promotes justice for all, equally and without discrimination, and that justice shall be administered in an expeditious manner that ensures no delay. The Constitution also provides that the administration of justice should embrace and incorporate alternative forms of justice, including reconciliation, mediation, arbitration, and other alternative dispute resolution mechanisms. This broad guide provides the basis and the premise upon which the judiciary and the justice sector operate in a bid to meet the justice needs of the Kenyan people. The bottom line of this constitutional command to the judiciary is access to justice. I want to state that in spite of the various barricades placed in our path, but imbued by the commands of the new Constitution, the judiciary has performed substantially well since 2010, when the new Constitution was promulgated. There is no doubt that the judiciary is still imperfect, but it stands out as one of the most reformed public sector institutions in the last decade, at least both in effort and effect. On every metric of service, our performance has been on an upswing. Jurisprudence, access to justice, case backlog reduction, enhanced integrity, court infrastructure, technology, staff welfare, accountability, public outreach, and so on. And this record is not a fairy tale. It is there to see in the 7 editions of SOJA that have been prepared and presented since 2012, and which are all in the public domain. In 2012, my predecessor, retired Justice Dr. Willy Mutunga, embarked on an ambitious judiciary transformation plan dubbed the Judiciary Transformation Framework, JFT. The JFT, which lapsed in 2016, facilitated fundamental structural and institutional changes that set into motion a number of processes geared at enhancing access to justice, which included case backlog clearance, leveraging on technology for service delivery, and expanded the court establishments and fiscal infrastructure of the judiciary in order to enhance fiscal access to the courts. I assumed office on the 19th of October 2016, and 3 months later, on the 26th of January 2017, I launched the current Judiciary Blueprint, Sustaining Judiciary Transformation, a Service Delivery Agenda 2017-2021. The SJD Blueprint has guided service delivery and the administration of justice in the judiciary for the last 4 years. The thrust of SJT was to build on the gains of the previous blueprint judiciary transformation framework by accelerating service delivery using the initial structures and systems that were put in place during the JTF phase. Thus, as a point of departure, the SJT emphasizes on improved work methods, enhancement of individual and institutional accountability, entrenching performance management, monitoring, evaluation, as well as optimizing technology for service delivery in order to achieve the pillars that undergird the strategy. Case backlog and the rising workload in the courts in Kenya is a perennial challenge and concern for the judiciary, and I'm sure by the public at large. Case clearance thus remains a core focus for both the JTF and SJT documents, with impressive results over the years. During the launch of the SJT at the beginning of my term, I made a pledge to the nation that the judiciary was to clear all cases that were 5 years and older, and do so within 2 years. At that time, there were 170,186 cases that fell in this category. And with the passage of time between 2017 and 2020, some more cases transitioned to the 5-year category. Ladies and gentlemen, I'm happy to report this morning that through various strategies, the judiciary was able to clear a total of 201,206 cases that were 5 years old and over between the period of January 2017 and June 2020. At the end of the reporting period, that is June 30th, 2020, there were only 35,359 cases that were 5 years old that remained unresolved, representing a 71% overall reduction. That feat was achieved as a result of dedicated strategies such as service weeks, which saw judges and judicial officers move to stations with heavier backlogs to assist in clearance of those cases. Besides the clearance of the older matters, an analysis of the rate of disposal of matters in courts, that's case clearance rates, also shows that courts have greatly improved in their efficiency in the disposal of filed cases. A total of 337,510 cases were filed in our courts during the period under review, out of which we resolved 289,728 during the same period. When I took over office, the case clearance rate, which measures the rate at which courts clear cases filed within a given period, was at 42%. This increased over the years to 97% in the year 2018-2019. However, due to the disruption of court activities caused by the current coronavirus pandemic, the case clearance rate fell by 10% to 87% as at June 2020. Despite this impressive effort to clear all cases, case statistics over the years show a steadily increasing workload for the judiciary. In the year 2016-2017, there were 499,341 cases pending, which number rose to 533,187 in the year 2017-2018, and further to 569,859 in the year 2018-2019. The figure was 617,582 as at the end of June this year. The trend of rising caseload is consistent in all tiers of our courts. The Court of Appeal, for instance, is statutorily required to have a complement of 30 judges, but is currently served by only 16 judges, about half of its legally established complement. As a result, in spite of the best efforts of the judges of that court and the court's most enthusiastic and robust application of technology, the case backlog in the Court of Appeal, that is cases over 1 year, have shot from 3,681 in 2018-2019 to 4,982 this year. The case clearance rate for the Court of Appeal has also fallen from 51% to 41% during the same period. I may add that there is a similar general trend that is observable across all the courts. The rising workload in the courts is evidence that the judiciary is increasingly unable to cope with the rising numbers of cases that are filed in our courts, an issue that I will revert to in these remarks. Without increasing human resource capacity in the number of judges and judicial officers, the elimination of case backlog will remain a pipe dream. The Constitution calls upon the judiciary to ensure means and channels of dispensation of justice beyond court adjudication of cases. A number of measures have been taken to enhance the dispensation of justice through alternative forms of dispute resolution, ADR, with promising results. Strategies in this regard include the implementation of court-annexed mediation program with very promising results. During the period under review, some 3,540 matters with a total estimated value of 13.5 billion Kenya shillings were referred to mediation, and 1,077 of these were successfully settled. An estimated 3,000 cases are currently referred to court-annexed mediation program, and the records we have show that about 11.5 billion Kenya shillings tied up in litigation is released annually into the economy. Recently, the judiciary also launched alternative justice system policy, which will guide on the accommodation of traditional and indigenous justice systems, and implementation is underway. A survey we conducted ahead of the rollout of HIS revealed that over 90% of disputes are resolved away from the courts in forums such as indigenous or traditional systems, religious organizations, and other non-judicial systems of justice. We only handle 10% of the disputes that find their way to the courts. It is therefore necessary that our justice system recognizes and takes on board these systems of justice that serve the needs of our people. Finally, on the modes of informal and expeditious disposal of cases, the judiciary is in the process of operationalizing the small claims courts, which are meant to ensure faster disposal of matters whose value is below 1 million shillings in a rather informal way. It is expected that a significant number of cases will also be disposed of through this initiative. On access to justice, we have made significant progress in enhancing the physical coverage of courts in a bid to reduce the distance court users travel to our courts. There are 61 ongoing court construction projects, 28 of which are World Bank funded through the Judiciary Performance Improvement Project, JPIP, while the rest are funded directly by the Government of Kenya. We have also seen increased partnerships with county governments, members of parliament, through the Constituency Development Fund, KITI, and other development partners who have supported the construction of court premises across the country. During my tenure, we managed to complete and open a total of 18 court buildings. In areas we have not managed to set up courts, we run mobile court programs in order to reach the far-flung areas that are underserved. There are 60 mobile courts currently in operation across the country. One of the critical pillars of SJT is harnessing technology for service delivery. In this regard, we have made significant advancement in the uptake of technology to enhance service delivery. The judiciary embarked on automation of court proceedings and the digitization of court records, and continued to implement the case tracking system, which enables courts to track a case from registration to disposition. The system was installed in 26 new courts, bringing a total of 61 courts installed with CTS. Out of the total of 469,041 cases entered in the system since its introduction, 256 and 41 cases joined during the year under review. To assist in this exercise, 1,300 computers were acquired for various courts and offices during the year. Connecting our courts to a stable and reliable internet has been a key and a primary objective, as this forms the basis for other technology-based strategies for service delivery. At the start of SJT in 2017, only 34 courts were connected to internet. Over the last 4 years, this number has since grown to 147, which has enabled the judiciary to implement a number of solutions, especially during this period of coronavirus pandemic. Having previously made false attempts at automating our proceedings and digitizing our records, from the 1st of July this year, we made a bold decision on advice of the technical people, and started the e-filing system in all courts in Nairobi and the environs. The e-filing system, which is part of the strategy to leverage on technology for efficient and expeditious service delivery, had initially been piloted at the commercial division of the High Court. Since then, almost 3,000 law firms have registered onto the system. Over 20,000 new cases have been filed, and over 250 million Kenya shillings in court fee collected through the system. I must admit, we are currently experiencing some system challenges, but these are teething problems which are associated with such a huge new system. I want to thank the Law Society in particular for their continued support and encouragement in this regard. Even as they raise their challenges and complaints, they are steadfast in their resolve that we are not going back and that we should continue, and I want to thank them most sincerely for that. The challenges are continuously being addressed, and I'm sure we will soon overcome. As soon as we complete the ongoing recruitment of more ICT staff for support, the system will be rolled out to all parts of the country as soon as possible. While the current measures to combat COVID-19 resulted in downgrading of in-person court operations and other measures geared at placing the pandemic under control, the leveraging on technology has enabled us to continue offering service to the Kenyan people. So you can see how important technology is for our service delivery. I'm confident that these achievements, as well as several other components of judicial digital transformation, which are captured in the Judiciary ICT Master Plan, will be progressively implemented to facilitate the enhancement of access to justice. Despite the progress and the steps made in the years of operation of SJT, I must point out that we have achieved some of the above enumerated results under fairly difficult circumstances. The judiciary's performance would certainly have been different and a lot better, but for three reasons: interference with and frustration of the judiciary's independence, refusal to grant the judiciary financial autonomy, and disobedience of court orders. It is indisputable that during the former constitutional era, like it was during the colonial era, the judiciary was an appendage of the executive. Although the Independence Constitution textually embraced the doctrine of separation of powers and provided for an independent judiciary, that separation was only on paper. The judiciary remained substantially at the call and the beck of the executive arm of government. The history of that subservience is well documented by legal historians and government experts. This judicial subservience has serious implications for individual liberties, human rights of citizens, shared prosperity, and even economic development of the country. It is, in large part, this subservience that triggered Kenya's clamor for a new constitution and a demand for an independent judiciary, both in the letter and the spirit of the law. As the reports of the Constitution of Kenya Review Commission and the Committee of Experts demonstrate, Kenyans deeming judicial independence an imperative for it to effectively discharge its mandate, created one in Chapter 10. It is this single-minded demand from Kenyans that culminated in the enactment of provisions such as Article 160 of the Constitution of Kenya 2010, which provides that in the exercise of the people's judicial authority, the judiciary shall be subject only to the Constitution and the law, and shall not be subject to the control or direction of any person or authority. As regards the appointment of judges, Article 166(1)(b) of the Constitution states that the President shall appoint judges in accordance with the recommendation of the Judicial Service Commission. Despite this clear provision and the 3 court orders, the President has failed to appoint the 41 judges, now 40 because one of them has since died, unfortunately, recommended to him by the Judicial Service Commission. Article 166(1)(b), and indeed the entire Constitution, does not require the President to perform any other act upon receipt of names recommended by the Judicial Service Commission, but to appoint them. Both the High Court and the Court of Appeal have been categorical that the President has no residual legal power to question or reject the names recommended to him by JSC, but to appoint them. The President cannot cherry-pick from the list of nominees. If that is allowed, ladies and gentlemen, the independence of the judiciary will be irreparably ruined, and the presidential mischief and patronage in the appointment of judges that was prevalent under the old Constitution, and which is precisely what the new Constitution sought to remove by these new provisions, will effectively be restored. If indeed there are any of those nominees with integrity issues, as it is being alleged, which were not brought forward at the point of their open and public interview, this very Constitution has a mechanism for dealing with them. That is, to appoint them and lodge complaints with the Judicial Service Commission for their removal. In any case, since the promulgation of the Constitution 2010, the Judicial Service Commission has referred a total of 7 judges, some of them very senior, to be investigated by tribunals. Some of these decisions have been made pursuant to the petitions by very ordinary people, meaning that a factual petition by the President would definitely be promptly investigated and acted upon according to law. The history and the record of JSC of acting against judges when presented with facts demonstrates that the constitutional mechanisms for dealing with any claims of integrity against judges is working, and the invocation of non-disclosed claims cannot be used as a barrier against the appointment of any judges, particularly when it runs afoul the Constitution and violates the very well considered and rendered court decisions. This failure to appoint the 41 judges is clear interference with the independence of the judiciary, with the result that backlogs in our courts have continued to soar. I continue to urge the President to appoint those judges without any further delay. If we had completed the appointment of those judges, the JSC would have immediately embarked on the recruitment of 30 High Court judges as per the request by the principal judge of that court after needs assessment. The Court of Appeal, which is currently operating at half its capacity and accumulating backlog as a result, would be fully operational and decentralized. The long outstanding land and labor cases that continue to violate people's property rights and undermine vital agrarian-based economic activities will not abate unless the land and environment relations judges on that list are appointed and sworn in. The cost to Kenya's productive capacity by the continued refusal to appoint these judges is incalculable. Its cost to our reputation as a country governed by the rule of law and the known precepts of constitutionalism damages the health of our democracy and its institutions. Financial autonomy is a critical aspect of judicial independence. For it to effectively discharge its mandate, the judiciary requires not just adequate financial allocation, but also financial autonomy. Currently, the judiciary lacks both, as only 47% of its financial requests are funded, and the executive has failed to operationalize the judiciary fund. Somebody get me some drinking water. Thank you. Sorry for that. The judiciary would be terribly weakened if it were left to the benevolent discretion of an arm of government, against which it at times decides cases, as it should and does, in critical matters. It is on record that when, in the case of Institute of Social Accountability and another versus the National Assembly and 4 others of 2015, the High Court rendered its decision on the issue of the constitutionality of the Constituency Development Fund. Parliament threatened to reduce the judiciary budget. When, in September 2017, the majority of the Supreme Court nullified the presidential election, it is on record that the President threatened to revisit. And the following financial year, we saw a reduction of the development vote of the judiciary budget from 2.1 billion to a paltry 50 million shillings. 2.1 billion to 50 million. That's why all over the country, GOK-funded court buildings are not completed yet, the World Bank ones have and are being completed and launched. There are many other occasions when the courts have decided cases against the established positions of either the executive or the legislative arm of government, and sadly faced reprisals in various ways. Contrast these reprisals with how the JSC has operated and continues to operate. If it may give you comfort, you may be glad to know that the Judicial Service Commission, which employs, promotes, and initiates disciplinary action against judges and magistrates, has on some occasions had court orders issued against it. If it appeals and loses, as it has had at times, it obeys those court decisions. And those court decisions have no bearing on the career stability or progression of those judges and magistrates who have issued those orders. We have not gone on a petulant rant against the judicial officers who are just doing their job. And in my view, ladies and gentlemen, that is the way it should be. It is on the basis of this background that the people of Kenya enacted Article 173 of the Constitution to guarantee the judiciary financial autonomy and, in turn, guarantee judicial independence. Clause 1 of that article establishes the Judiciary Fund, and Clause 4 thereof directs that upon approval of the estimates by the National Assembly, the expenditure of the judiciary shall be a charge on the consolidated fund, and the funds shall be paid directly into the Judiciary Fund. End of quote. Whereas the enabling legislation and regulations have been put in place, as stated, the Judiciary Fund has not been operationalized for the judiciary budget to be deposited in that fund, as required by Article 173(4) of the Constitution. Furthermore, an analysis of the judiciary budget reveals a steady decline in funding to the judiciary, which presently stands at less than 1% of the national budget. This has been compounded by abrupt and irregular budget cuts that disrupt service delivery and other important processes within the judiciary. There are some years, for instance, when the ICT budget has either been wholly slashed or has not been provided for altogether. And this despite the fact that ICT is core to the judiciary transformation. The inevitable impact of these constraints is the build-up of caseload in our courts, which I pointed out earlier. It is indeed a miracle that the judiciary has continued to deliver services to the people of Kenya, thanks to the sacrifices of our judges, judicial officers, and staff, and the support we have received from the World Bank and other development partners such as IDLO and UNODC. I spoke earlier of the measures that we have taken to complement courts in the dispensation of justice through ADR and alternative systems, as well as the operationalization of the small claims court. However, due to underfunding, these initiatives have taken off in less than the optimal function. We have no money to pay mediators or court adjudicators fees, which has undermined access to justice and in turn undermined the country's ranking in the World Bank Ease of Doing Business report. The net result of all these, ladies and gentlemen, is that the backlog of cases will continue to rise. With the current judge population ratio standing at 3.13 judges to a million people, and the case load now standing at 617,582 as at 30th June 2020, it is going to take about 2 years to clear just this caseload if other cases are not filed. But of course, that is unrealistic expectation. In reality, Kenyans file an average of 400,000 cases a year against 300 cases that the current number of judges and magistrates are able to clear every year. The other disturbing trend is the routine disobedience of court orders by the executive arm. And I'm not here only referring to the disobedience of court orders involving prominent people in our society. I'm here referring to court orders generally. For instance, a poor peasant takes his neighbor to court for trespass, and the case takes a number of years to determine before he obtains a court order. As the judiciary has no coercive power, it depends on the police to effect such an eviction or assist in such an eviction. When the warrant of eviction is given to the police, some of them start a new trial at the police station, presided by police officers, literally questioning the propriety and wisdom of the court decisions. Similarly, there are many cases involving the government as the judgment debtor, which are routinely disregarded, leaving the decree holders scornfully deriding the judiciary for issuing paper judgments. Ladies and gentlemen, I can't emphasize more. This is a terrible dent in the administration of justice in this country. There are many such judgments in which wananchi are suffering. Ladies and gentlemen, we are either a nation governed by the rule of law and the principles of constitutionalism, or a jungle republic that Thomas Hobbes talked about a few centuries back, where life, when he said where life is solitary, poor, nasty, brutish, and short. And the history is replete with examples that those who nurture the tree of impunity tend in the not too distant future fall victims of their own labors. It is in this vein that I ask Kenyans to reflect on the constitutional changes that are proposed. The true north, ever constant criterion in assessing any changes affecting the judiciary, should be whether the envisaged changes aggrandize or diminish judicial independence. Any changes which breaches the separation of powers or threaten judicial independence could be, without a doubt, a very dangerous retrogressive from the path of constitutionalism Kenyans chose in 2010. As I exit in the next few days, I want to assure Kenyans that I leave behind a solid judiciary. The judges of our courts have made the judgments our courts have made since the promulgation of the Constitution in 2010 attest to this. My fellow countrymen, if you want our courts to determine cases within 2 years and attract investment, as happens in countries like Singapore, your parliamentarians, Mr. Speaker, your parliamentarians have to commit reasonable resources to the judiciary. To avoid reprisals when courts decide cases against the powers that be, have the judiciary constitutionally guaranteed an allocation of at least 3.7% of the national budget, and have it deposited in the judiciary fund immediately after the budget is approved as required by Article 173(4) of the Constitution. Only these measures will truly inoculate the judiciary against the vagaries of short-term political interests expected of the political branches of government. Without that, such proportionate investment in the judiciary, and without increasing the human resource capacity in the number of judges and judicial officers, my fellow countrymen, I want to tell you that the elimination of case backlog will remain a pipe dream. Many of our leaders have, and quite justifiably so, beseeched me to open courts in their areas. Many governors, and I want to thank them, have donated pieces of land to the judiciary to construct courts. A number of MPs, and I also thank them, have gone as far as constructing court buildings with the CDF funds. That is clear testimony of the dire need for courts in many parts of our country. I want to say this, ladies and gentlemen, and fellow Kenyans. Allocate between 5 and 10 billion shillings to the judiciary development kitty every year, and you will have appropriate courts in every corner of the country. With very little resources, actually less than 12 billion, the very important support we have received from the World Bank through JP project, we have already demonstrated that this is possible. To my fellow judges and magistrates, despite all the above enumerated challenges, I beseech you to continue doing your very best. Please be courageous and discharge your duties with unwavering integrity and true to your oath of office. You are the hope of this country. I have been told that many times, and I'm sure you have also been told. Kenyans are proud of you, and myself as your Chief Justice, I am very, very proud of you. Fellow judges and magistrates, please remember that the judiciary plays a critical role in the political stability and economic prosperity of this country. If you falter in the discharge of your duties, especially in the determination of electoral disputes around 2022 general election, what we experienced in 2007-2008 post-election violence would easily recur with worse intensity and implications. Please, 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 judges, don't let that happen. As I conclude, I want to say that many of the achievements that I have enumerated above would not have been possible without the support of many stakeholders. I therefore wish to sincerely thank the Judicial Service Commission. Members have sometimes made you sit late and for very many long hours, but you have graciously endured. At times it has appeared in the media as though there are conflicts among us. I want to assure the nation that we have worked and are working very well together. Differences of opinion should not be taken as conflicts. I want to thank my Deputy Justice Philomena Mwilu and my Chief Registrar of the Judiciary. I sometimes tell people that these women give me hell, but it is good. These ladies have taken my calls even late at night. I want to thank you most sincerely. CRJ, yesterday you ordered me to come back and I came. I had gone home and she ordered me to come back and I came for important work. You can see how we work. I want also to thank the entire judiciary community for your support and commitment to a judiciary that delivers. Despite the poor working conditions, your cooperation and commitment to a common agenda in the pursuit of justice and needs of the Kenyan citizenry has been steadfast. I thank the entire justice sector for the cooperation and support that you have accorded me over the last 4 years of my leadership. Through the National Council on Administration of Justice, we have made important gains and achievements in ensuring coherence and coordination of the justice services in the country. Indeed, the manner in which we have managed the COVID-19 pandemic in the justice sector is evidence of this cooperation and commitment to seeking common solutions. I also want to thank the development partners. I can see some of the representatives here. The European Union and UNODC, through the PLEAD project, you have been relentless in your investment to have the voiceless in our marginalized parts of the country heard and their just needs met. To IDLO, as you have done with other several departments, both in the executive and the legislature, you have been a bulwark of many of the activities in the judiciary. Were it not for your support and wavering support, the current digitization of the judiciary, especially the e-filing system, would have come a crowbar. The Danish, the Dutch, the British, the German, and the American embassies, just to name a few, the judiciary is indebted to you all. I also want to thank the other arms of government, that is the legislature and the executive, for the cooperation they have given me. Finally, and most importantly, I have no suitable words to thank you, the Kenyan people, for your unwavering support for me. That lady I met in Rome, that engineer I met at Heathrow Airport, that gentleman I met in Vienna, that live timer I met at Kodiaga prison, that student I met at Kenya High School, that lady I worshipped in the Pentecostal Church, Valley Road, at the invitation of Bishop Oginde, that Catholic priest I met in Kakamega, that pastor of the Seventh-day Adventist Church, now deceased, who urged me to be courageous and not to be a living corpse. Not to mention the numerous others here in Kenya and other places, most of whom I have never met, who have accosted me and given me words of encouragement. And not least to my wife and children and my larger family. I want you to know that your kind words gave me courage and stamina to soldier on in spite of the challenges I faced. To my fellow Christians, the Seventh-day Adventist Church, and all fellow Christians from other denominations, as well as my brothers and sisters in the Islamic, Hindu, and other faiths, particularly those of you who woke up and lifted me up in prayers, even when I was myself asleep. You are to me Aaron. To all of you, I say thank you very much. To our President, wherever you are, it is clear there is a difference of opinion between me and you. But I want to assure you and the entire nation that I have nothing personal against you. To the contrary, as you know, Mr. President, I have given you respect as our head of state. Why would I want to fight you, as some people are suggesting? I am apolitical, and I hold no brief for any politician. The security and the intelligence services can assure you of that, and I'm sure they have assured you of that. Once again, to all Kenyans, thank you very much. It was my singular honor and privilege to be of service to you as your Chief Justice. If in any way I annoyed you or I did not live up to your expectation, please understand that I'm only human and forgive me. Though I did not achieve what I planned to do, I retire a very happy man. Above all these thanks and support, fellow Kenyans, I want to thank the Almighty God and categorically state that I've seen God's hand in many of my affairs throughout the 4-year period I have served as the Chief Justice of this great nation. He has thwarted numerous nefarious schemes against me and guided me to this day. I have many times in tears gone down on my knees to thank him. He has shown me a glimpse, just a glimpse of what it entails when one seeks to honor God in one's work, especially in high and sensitive positions like the one of Chief Justice, which he privileged me to occupy. I will be eternally grateful to him for considering me worthy of his favors and mercy in spite of my sins. To God be the glory. God bless you. God bless Kenya. Thank you very much.